But there's a little more to it. So joining us now to discuss this is attorney Anahita Sedaghatfar. She is counsel for the Cochran firm. She has been looking over this case. You and I were talking about it earlier. We have to take into consideration how she died and during what activity.
That's right. That's the defense perspective. And obviously, I don't think that these records should be released. I think they should be kept under seal. But the defense attorneys are doing exactly what they should be doing, and that is anything and everything to get this guy out of a life sentence. And so they're arguing, look, we have this evidence of this victim's alleged prior sexual history that will show she engaged in rough sex. She engaged in S&M sex, and we should be able to use that evidence to argue that this was not a murder, this was not a rape, that it was consensual, and she died during rough sex.
There you go. So she died from asphyxiation, from being choked during that activity.
All right, there are rape shield laws in every state. What's different here? What's going on in New Hampshire?
Well, that's why this case is so critical, because that state also has a rape shield law. And these laws say that we want to encourage victims of rape to come forward and report rapes without fearing that their sexual history will be made public and used against them, right? And the public policy behind that is we want to get and convict rapists. We want them off the street. And so if the court adopts the defendant's argument here and says, okay, let's unseal her sexual history, this will open the door to any and all criminal defendants in rape cases to do the same thing. And in my opinion, I think it will destroy the rape shield laws and the purpose of them.
Well, does it matter that the victim has died?
Well,
that you can't really embarrass someone who no longer is living?
You still have privacy rights, and you can. I mean, that individual should not have her sexual history used against her. Let's say they do have this alleged evidence, and they present it. Okay, so let's say she consented to this type of sex 100 times, 1,000 times, 2 times. That doesn't mean she consented this time. And so I think it's very problematic. Again, it's a slippery slope to open that door.
So legal minds across the country, I'm sure, are watching this very closely. What happens next?
Well, so now we're waiting for the appellate court to make a ruling. Hopefully they'll do the right thing. And I sympathize with the family. They're begging the court not to do this. They're saying, look, our daughter is dead. She was victimized. Don't re-victimize her. And let us keep our dignity as a family. I mean, it's humiliating. And I really think we need to keep an eye on this case because it is so critical.
But interestingly, and this is where being a defense attorney comes into play, you're saying you would be doing the exact same thing.
I would be doing the same thing. That's the defense attorney's job. I know they're getting a lot of heat for this, but you know what? That's what they have to do. They have to pull out any and all stops that they can to save him from a life sentence.
So if the family and the prosecutor, if they lose this, what happens? Do they have any kind of recourse?
So then if the defense wins the motion, then the court will unseal the records and they'll decide whether or not the conviction should be overturned.
Okay, and then the other side. I'm thinking the other side. What can they do?
They can't do anything because this is the defendant's opportunity to appeal. And so if he wins the appeal, they open up the records and he's seeking to get his conviction overturned by the appellate court. Just on this point, he's saying, look, the lower court didn't allow this information in. Had it come in, I wouldn't have been convicted. So that's the basis of the appeal.
Wow.
Interesting.
Yes.
Anahita, thank you very much, and we'll watch the case and see if it has any effect here in California.
Yeah, thank you for having me.
Fascinating. Thank
you.
Thank you.
Now,
all right.